hurdle still stands in the way of the Jubilee Alliance's march to State House. The coalition's presidential aspirant and Deputy Prime Minister Uhuruto and his running mate William Ruto now will have to wait until next Friday to find out if they are suitable to run for office. And as KTN's Catherine Umwanto reports, the High Court is being asked to dismiss the integrity case by Uhuru and Ruto's lawyers and let Kenyans decide on their integrity at the polls.
25 days to the election, and yet another legal hurdle has been thrown in the way of the Jubilee Alliance's presidential candidate Uhuruto and his running mate William Ruto. A 5-judge bench heard the submissions from both the claimant and the respondents in the case. The claimants, through their lawyers, say the High Court has the jurisdiction to try the case to conclusion and that the matter is not political. However, the same benchmarks used to appoint public officers should also be used to vet those vying for elective posts, a claim the respondents, that is Uhuru and Ruto, rejected.
My lords, our petition has nothing to do with presidential election. If you look at the declaration that we are seeking, we are saying that those who are seeking state office must be taken through the rigors of integrity that other state and public officers are taken through by law.
First, it's speculative. We don't know whether these people will be elected as president. And as Stella Mwini has submitted, the High Court has no jurisdiction to dwell on speculative matters. It's not a justiciable issue.
The argument that the High Court has no jurisdiction to rule on the eligibility of the two politicians stems from the fact that the government has put in place various institutions that can handle such issues, such as the Registrar of Political Parties, a Supreme Court tribunal, and the Independent Electoral and Boundaries Commission. No case has been brought before the Supreme Court or the Chief Justice, and the Registrar of Political Parties, Lucy Ndungo, and IBC have rendered the two fit to vie for office.
Even if they were elected president, the Constitution has removed the jurisdiction of this court from hearing any challenges to a president, sitting president. The Constitution provides that the only forum for challenging a president is through the impeachment provisions by the Senate.
That at this early stage of the implementation of the Constitution, the legitimacy of legal issues have to be ensured.
The suit challenging the eligibility of Uhuru and Ruto was filed by the International Center for Policy and Conflict. The group is seeking to have the two barred from contesting the March 4th election on grounds of the charges they are facing at the International Criminal Court.
Particular witness number 4 has been brought as a witness because not only has he counted the evidence, but he has said that the evidence he gave to the International Criminal Court was false, was a fraud, and the advisement to the prosecution has led the prosecution to drop that particular case.
The ruling by the 5-judge bench on the 15th of February will have a great impact on the March 4th poll, and therefore all eyes will be on the High Court to see what they decide. Catherine Umwanto, KTN in Nairobi.